Hi, everyone. This is Sam Silverman, Managing Partner of EB-5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be discussing adjusting status with an EB-5 visa investment, and we'll also spend a few minutes discussing some recent EB-5 visa demand trends as well with respect to both high unemployment or urban TEA projects and rural TEA projects as well. All right. So first, a little bit about EB-5AN. We're a leading EB-5 investment fund manager. We've been in the space for about 12 years at this point. We own and operate more than 10 regional centers that cover the entire continental United States. And we've worked on many projects around the United States, ranging from Florida to Colorado, Georgia, North Carolina, Utah, and Wyoming, to name a few. One of the things that sets us apart in the EB-5 industry is a commitment to 100% investment transparency. Unlike many of the other regional center operators, we endeavor to make all of the offering documents and projects and guarantor financial statements available to all of our investors so they can get the full picture of all available information prior to making an investment decision. We also have an extremely active blog and YouTube channel with over 1,000 videos and hundreds of posts about best practices for diligencing potential EB-5 projects. So we encourage you to take a look at some of those resources and get educated about how to evaluate a potential project. As I mentioned earlier, I'm Sam Silverman, one of the two managing partners. A little bit more about my background and bio is here on the left-hand side of the screen, and my partner Mike there on the right side. And as I mentioned earlier, we cover the entire continental United States and Puerto Rico, so that means we can seek out the most compelling and safest rural and urban EB-5 projects around the country. We're not wedded or focused on any one particular geographic area. We've worked with investors from around the world. Most importantly here is that people of many nationalities and backgrounds have consistently found value in our investment approach to EB-5 projects. We've also been featured in many leading publications. Some of them are listed here. And now, without further ado, I'm pleased to introduce our guest panelist, Anu Nair, one of the most experienced EB-5 immigration attorneys in the space, who's with Clasco Immigration Law Partners, which is one of the top immigration law firms in the United States today, if not the top firm. And so with that, I'll let Anu jump in and introduce herself and share a little bit about her experience with the EB-5 program and what she's seeing in the last year or two under the new EB-5 rules.
Sure. Hi, Sam. Hi, everyone. Thank you for joining. So my name's Anu Nair. I'm a partner here at Clasco, and specifically, I manage our firm's EB-5 investor team, and I've been doing so since about 2012. So in the last decade plus, our firm has processed well over 2,000 applications, and we also review filings for other firms. And we also tend to take over cases that have received really difficult requests for evidence, notice of intent to deny, or appeals on source of funds issues. So I've been really lucky to have a really great team of attorneys who work for me, who work with me. And I am really proud that we have a really fantastic approval rate. And part of that is because we are a very attorney-centric team. So all of the cases are processed by our attorneys. And in addition to taking investors through the EB-5 process, the first stage of the EB-5 process, we've helped thousands upon thousands of EB-5 investors and their families in obtaining their green cards and taking them through the 829 process, and then finally getting their citizenship as well. So in the last year or so, I would say the EB-5 space has really boomed, maybe not to the 2015 levels that we were seeing, but really increased as more and more people are looking to find independent, self-sponsored ways to get their green cards. And the biggest boom seems to come from those applicants who are already in the United States, either on an H-1B, an L-1, an E-2, and sometimes even on an F-1, where they're just tired of wading through the family-based or other employment-based options and are switching over to EB-5. And I'm sure we'll cover this a little later on, but part of that boom is really coming from the RIA, the law that was passed in 2022, that really helped to bring down processing times for the 526 petitions. So we were able to see people getting their green cards in under 2 years from filing, which is really unheard of now in almost any other category. So that's just a little bit about me and a little about the EB-5 space in the last year.
All right, perfect. Thank you, Anu. All right, so let's jump into today's main topic, adjusting status with an EB-5 investment. So there are a couple of different benefits here. But first, let's walk through these and just first start with who could potentially avail themselves of this benefit, since this is not available to every single investor who's doing EB-5.
Right. So the requirement is that you have to be physically present in the United States in order to file a green card application. Now, you can do that concurrently, which means along with your 526 petition, you can file your green card application, or you can file your green card application at any point before the 526 petition is approved, or even subsequent to the 526 approval. The major requirement, of course, is that the visa bulletin has to be current in order for you to file the green card application, and we'll talk a little bit about that later on. Now, there are lots of terms of art that we use, so you'll probably be used to hearing a green card application, adjustment application, or a 485. All of those mean the same thing. They are your green card application. One of the major benefits of filing the green card application is allowing people a basis to remain in the United States, especially now that we are seeing, unfortunately, a higher terminations for H-1B L1 employees. This has become a real boon to those applicants who were laid off and now have an alternate way of staying in the US. Because by filing a green card application in the US, you are under a period of stay that's authorized by the Attorney General, which means that you're allowed to remain in the US as long as that green card application remains pending. And then if you're going to school, you can continue to go to school while that green card application is pending. For work authorization, if you're maintaining your H-1B, your L1, your E2, your OPT, you can continue to work even after you file your green card application. But let's say we're talking about the worst case scenario, that you've been terminated from those or you lost those statuses, then you can apply as part of your green card application for work authorization and travel permit. And as soon as that work authorization approved, you now have independent work authorization. Again, why this is so important to a lot of clients is unlike an H-1B or an L1 or even an E2 that's limited to a specific employer, or unlike an F1 OPT where your employer will have to sign off on documents and you have to remain employed in a field that's similar to your specialty for your degree. This is an absolutely independent employment authorization. You can work for any employer that you want. You can work for no employer and just go to school or spend time at home. So it's a lot greater, it's a greater benefit for a lot of clients. And as I mentioned, you'll also be able to apply for and get a travel document while your case is pending. Now, the benefit to this is you can travel in and out of the US on that status after your travel permit is approved. There are some restrictions for travel if you're on any visa applications besides an H or an L. So it's important to make sure that you are speaking with your attorney before you travel after you file your green card application. But again, you will be able to apply for an independent work authorization and travel permit. And a lot of clients like this because while their 526 petition is pending, Even if there's a backlog, while that backlog is happening, they have the benefit of essentially living, working, and traveling in the US, which is basically what a lot of people want for their green card application. If they have children going to school here, that does not get disrupted because the children can continue to go to school here based on the fact that they have a green card application pending. Now, a lot of people talk about citizenship, but they always forget about the first step, which is that you need to become a green card holder before you're eligible to apply for citizenship. So applying for the green card in the US is going to be a significant step towards eventually being able to apply for citizenship. So a lot of applicants are really looking at this benefit, especially given a potential concern about their employment and their resulting temporary status in the United States. So what I'd like to do is cover the types of categories of applicants who generally apply for adjustment of status in the United States. So the most common that I mentioned is an H-1B visa. These are specialty occupation workers. So they usually have an advanced degree, like a bachelor's degree or a master's degree, and they're here temporarily for either 3 years or 6 years, and then can extend their application or extend their H-1B if their employer sponsors for them. Unfortunately, for a lot of applicants, getting their employers to sponsor them is not a realistic option. Indian nationals, especially Chinese nationals, have a really long visa wait time from the time the employer sponsors them until they finally become eligible for a green card. And during that whole time, they have to continue to maintain that H-1B status. So we see a lot of people who are trying to get out of that H-1B pipeline who then are eligible to apply for a green card. Similarly to an L1, which is for executives and managers, they may be able to apply for an EB-1, but it's rare that they'd be immediately eligible for an EB-1. So we do tend to see a lot of people in L1s, especially those who are not multinational managers, who are going to be applying for a green card through the EB-5 process. The great thing about H-1Bs and L1s is that you are allowed to have dual intent, which means that you are eligible to file for the green card application and continue to maintain your H-1B or L1 if you choose to do so. Some clients prefer that. Some clients want to maintain that H-1B L1 until they have their green card physically in their hand. Others will say as soon as they get the work authorization, they want to give up that employer-sponsored petition and now have an independent basis. Then let's talk about 3 other common types of applicants who apply for green card in the US. The next common type are E-2 visas. These are business owners who have a business in the United States. It doesn't eventually lead to a green card, but now they do become eligible or they are able to file for an EB-5 and a green card application. There are F1 students who are here attending either undergraduate or graduate school and don't want to try to find an employer to sponsor them or get worried that they're not going to find one in time, and then switch over to an EB-5 with a concurrent green card that gives them that work authorization, which makes them more competitive in the labor market. So those 2 I specified and kind of separated from the H-1B and L1 because these 2 are not dual intent visas, meaning that once you apply for the green card application, you have to remain in the United States until your travel permit is approved, and then you can travel. So these are the ones that have travel restrictions. And additionally, we'd want to make sure that the timing of the green card application filing makes sense for these 2 types of applicants, because every time you enter on an F1 or an E-2 visa, you're telling the government that you don't have intent to reside permanently. So there are timing concerns in terms of when you can file and how quickly you'd be able to travel internationally on those 2 visas. Now, the last one I want to focus on is a B1, B2 visa. These are tourists for business or visitors who are coming to the United States. And some applicants will come into the US and then realize that, hey, this EB-5 option is available and allows me to file for a green card and remain in the US. So applicants who've entered on a B1, B2 and subsequent to that decide to file for a green card, fantastic. We usually generally tell them wait 90 days and then we can discuss and figure out what are the appropriate options. Where I try to dissuade people is coming in on a B1, B2 with the intention of filing for the green card application, which could lead to intent issues at the border. So that's not something that I recommend. But if you're in the US on a B1, B2 and you're considering an EB-5, it's certainly an option that does become available and you do become eligible to file the green card application. Sam, do you want me to take everyone through the steps of the process, or?
Yep, exactly. Let's spend a few minutes and just, we talked about eligibility. Now let's kind of walk through from signing through filing and how that fits together, both the financial part and immigration together.
Sure. So the first step that I always tell my clients is let an attorney take a look at your immigration history, your source of funds, and then make sure that all of the source of funds can be documented appropriately. Once that's done and you've signed the subscription booklet with the with EB-5AN, then you can go ahead and transfer the investment funds. Once the investment funds are transferred, if you're in the United States and eligible to file for the green card, you'd file your 526E petition. That's your EB-5 petition that says, here's the project I invested in. This is how I lawfully earned the money that I'm now investing in this project. Then you file your green card application, which is the I-485. This is you saying, I have an immigrant petition pending and I don't have any criminal or immigration violations that would prevent me from getting the green card application. Along with that, you file the 765, which is your work authorization, and the I-131, which is the travel document. Now, the great news is that the 765, the work authorization, and the travel permit are adjudicated independently of the green card and the EB-5 petition. And the reason I mention that is because that means as soon as you file these 4 applications with the government takes apart the work authorization and travel permit and adjudicates that first, meaning that they will review those documents and approve those documents while your other 2 applications are still pending. So historically, the work authorization gets approved first, and then the travel permit gets approved. But we're starting to see them being issued in a combo card, meaning both could get approved at the same time, and you get a card that serves as both your work authorization and travel permit. But again, these happen before the government even touches your 526 or your green card application. But once those are adjudicated, the case continues regular processing, and then your EB-5 petition or your 526 petition will have to be adjudicated first. Once that's approved, then the government will pick up your green card application and then approve that. And the timeline for that does vary a little bit, but generally well under a year after the 526 is approved, you get your green card approved. Some clients have gotten them approved in less than 2 months from 526 approval. Some clients, it can take about 8 months after 526 approval. It really depends on the timeline and flow of cases at the time. Once that 485, that green card's approved, you are a green card holder, and that green card status is valid for 2 years. 90 days before that expiration of that green card, you're eligible to file the last step of your EB-5 process, which is the 829 petition. You have to prove very little as the investor. You just have to show that you haven't committed any immigration, criminal violations, or you haven't, had any issues with the government that would prevent you from getting your green card application. The project shows that it spent the money and created the jobs the way they said they would at the 526 stage. And once that's approved, you are a full green card holder and you become eligible to file for your citizenship. And here's one part that I want to make clear. That entire time you spent in conditional green card status, so from the time your green card application was approved, even before you filed your 829 petition, while you're waiting for your 829 petition to be approved, all of that time count towards the 5 years that you need for your citizenship. So in short, again, what this really highlights a few of the sort of important reasons why people want to file a concurrent adjustment, which is getting that work authorization and travel permit even before the government picks up your EB-5 petition for adjudication. And then once the EB-5 petition is approved, the government already has your green card application on file that they can pick up for adjudication.
Okay, perfect. All right, and so that same information that we just covered is also kind of visually illustrated here. So 5260 goes first, adjustment of status in parallel, and then travel authorization and 829. So just another way to show that same information visually. Let's talk a little bit more in detail about what the benefits are for both the EAD and the advanced parole, and then we'll talk a little bit about the Child Status Protection Act as well.
Sure. One of the most important benefits of applying for a green card in the US is being able to apply for that work authorization and advanced parole document. Most of my clients who are filing for a green card application in the US, they've either lost their job, they've been told they're going to lose their job shortly, or they do want to get away from that employer-sponsored option. So the employment authorization allows you to work anywhere in the United States. You file for it with your EB-5 petition and your green card application. And as I mentioned earlier, you don't have to work for a specific employer. You don't have to work in a specific field. You don't have to meet a certain number of hours. And it lets you be more marketable because employers don't have to sponsor you. They don't have to maintain any records for immigration to review on your behalf. That would be, no different than if you were a green card holder or a citizen, meaning that all you do is confirm and fill out an I-9 application, but you don't have to have any other documentation that the employer has to hold on to. That really may help you be a little bit more marketable, because a lot of companies don't necessarily sponsor immigration options. With the work authorization, you do then become eligible to apply for a Social Security number, which can help you in other areas. I know some clients have said it's be really helpful to have that in order to open up a bank account, in order to buy a house, in order to open up credit cards, and that has really been helpful for them in those areas. Advanced parole is the document that you file that will allow you to travel while your green card application is pending. Similarly to the work authorization, you would apply for the advanced parole along with your 526 and your green card application, and then you'd have to wait for that to be approved before you travel internationally. And again, the benefit of that is if, let's say, you were in the US on an F1 OPT, and then you didn't get selected for the H-1B, and now you have to rely on your work authorization, and you can work for any company in the US, but you no longer can use that visa stamp in your passport because you're not on that F1 OPT. This advanced parole document will allow you to travel in and out of the United States without needing that visa, which you no longer have available to you. So temporary trips abroad you can use on your advanced parole and come back in on that.
All right, perfect. Let's spend a few minutes talking about CSPA and how that kind of fits in with an EB-5 application, since a lot of clients are doing this, to benefit some of their older children, and with potential backlogs in the future in either the rural or urban categories, this is an important point for some clients.
Right. So the Child Status Protection Act is a law that was passed to help families who had children who ended up sort of aging out of the process because of the long delays at USCIS. So what the government said was any time that the petition is pending with USCIS, the child's age is frozen as of the day the petition was filed with the government. Because previously, the age was not frozen, and a lot of children, as soon as they turned 21, lost eligibility. So this allows for the freezing of a child's age as soon as a 526 petition is filed with the government. Now, under CISPA, the requirement is that once a visa becomes available, you take the child's age at that time, you subtract it from the entire time your 526 petition was pending, and that's the child's CISPA age. And if that age is under the age of 21, they're eligible for the green card. Sounds really complicated, but the reason I mention it is because a lot of times if you start Googling CISPA, they do have this formula up. But essentially, you can consider your child's age frozen when you file the 526 petition, as long as there's no backlog. Then the requirement is that you then have to seek to acquire, meaning filing a 485, paying a DS-260 fee, filing a DS-260 application, filing an 824 application within 1 year of this becoming available, meaning that the 526 petition is approved or the visa is available. So when you are filing a 485 concurrently, and then there's a subsequent retrogression, the good news is that you already have done the sought to acquire requirement. And the as we've noted in the PowerPoint, there's no official guidance on this, but we've done this in other categories. So the I-140 petition that employers file for their employees have a similar mechanism for CISPA. And in those cases, the CISPA age has been frozen, and that does, filing the concurrent application does fulfill the seek to acquire requirements. So based on that, and if we were to extract what they're doing for the I-140 and apply it for the 526 petition, the children should continue to remain protected for CISPA benefits by filing a concurrent green card application. So for clients who have children who are 18 to 21, it's important that they file as quickly as possible because you do want to get them filed and protected before they turn 21. I have had some clients, and the reason at the outset I mentioned that there was a big boom in EB-5 in about 2015, and part of that was because there was expected to be a backlog for Chinese nationals in that category, and they very quickly tried to file before their children turned 21, and they were worried that that there was going to be a backlog in that category. So I expect something similar where more and more people are going to want to apply for this. And now that the RIA, the law that was passed in 2022, allows for concurrent filing of a green card application, there's now added protection for CISPA applicants. And I think it's going to be really helpful for those clients who have children who are 18 to 21.
All right, perfect. Let's shift gears and just talk about some ideas to reduce immigration risk with respect to the different underlying visas that an investor could be on when considering doing an EB-5 investment. Just what do clients need to be aware of?
I'm going to take the two visa statuses that are the easiest, which is the H-1B and the L-1 first. As I noted at the outset, H-1B and L-1s are dual intent, meaning that you are absolutely allowed to have an intent to reside in the US while you're on an H-1B. What that means is you can file your 526 petition and your green card application the day after you return to the US on an H-1B or an L-1, and there's absolutely no issue in doing so. So the H-1B and L-1 gives you the most flexibility, and the only sort of immigration risk that would come about is making sure, if you're going to have any issues with your employer, if you think you're going to be fired by your employer, I'd want you to file for a work authorization and travel permit. Even if you were planning on staying with the H-1B, it's still important to file those. So it's more about mitigating the risks than to address risks outside, at the outset. H-1, L-1s, best options when applying for a green card application. For an E-2, for an F-1, it's a little different, because for an E-2 visa and an F-1 visa, you don't have dual intent, meaning that at the time you last entered on your F-1 or your E-2, you shouldn't have had intent to reside permanently in the United States. Previously, there was a rule where if you undertook any action towards your green card application within the first 30 days of entry into the US, the government assumed that you lied at the border. If you take any action within 30 to 60 days of entry, there was a rebuttable presumption, meaning that the government assumed that you had this intent upon entry, but you can provide evidence that showcased that you didn't and you subsequently changed your mind. Generally, after 60 days, the government didn't review your intent. Now that has changed a little, and now the rule is that any action you take within 90 days of your last entry on this non-immigrant visas could show that you had intent upon entry. So the first thing is, if a client reaches out to me and they're on an F1, they're on an E2, they're interested in EB-5, my first question is going to be, when's the last time you entered the US? And if it's been more than 90 days, great, we can continue the process and talks and go ahead and file the EB-5 application. If it's been under 90 days, we can talk about what the next steps would look like, but I wouldn't want them to file their application within those 90 days. Now, this doesn't mean that the government can't ask you for confirmation that you didn't have intent during your last entry, but the risks reduce pretty significantly. The other factor to consider is you can continue to travel on an H and an L1 while your green card application is pending, but you can no longer use your F1 or your E2 while your green card application is pending. So sometimes clients will say, I'm not going to maintain my F1 because as soon as I get my travel document, I'm going to have to travel. Once you return back on that green card-based travel document, you're no longer in F1 or E2 status anymore. So that's why it's going to be really important that you don't travel until the work authorization is approved, so that once you re-enter the United States, you can continue to work without interruption. And I want to give a little bit of a hypo that addresses an H-1B L1 applicant and an F1 and an E2 applicant. So let's say I have an H-1B applicant who files for the green card in the US, and they file for work authorization and travel permit, but they have a family emergency and they need to travel, and so they decide to travel on the H-1B visa. They're absolutely allowed to do that. When they return back on their H-1B visa, their work authorization green card application will continue to remain pending, but the government will deny the travel document because they traveled while it was pending. But since they have an H-1B and they're only working for their H-1B employer, they can continue their H-1B status, and eventually, if they choose to do so, file for a new travel permit. So that travel restriction is pretty minimal for someone who's continuing to maintain the H-1B or L1. Now let's take the hypo. Similar situation, F1 student files for the green card, work authorization, travel permit. They have an emergency, they need to travel. They cannot travel on the F1. If they travel on the F1, the green card application, the work authorization, and the travel permit gets denied. They would have to wait until the travel permit is approved, or if in cases of a true emergency, they can request an expedite of their travel permit, and then they would travel outside of the US on that travel document and re-enter. And once they re-enter, they're no longer in F1 status. They are now in that status I mentioned before, which is a period of stay authorized by the Attorney General. So even if they had a valid OPT work authorization card, since they're no longer in F1 status, they can't use that card. They have to use the work authorization card based on the green card application. And that holds true for the E2 visa as well. So for those two applications, you have a little bit of a travel restriction before and after you file a green card while in those categories. For a B1, B2, it's similar to an F1 or an E2 in that you don't want to take any action towards a green card application within the 90 days of your entry into the US on that visa. The difference, and this is where it can get a little complicated for some people enter the US with their children because they're going to Disney World or they're visiting family members, and then their family talks about EB-5 and they decide to pursue that option. But now they have to wait at least 90 days before they take any action towards that EB-5. And then it can take some time for them to turn around and file for the green card application. While you're on a B1, B2, you don't have any work authorization. So you have to continue not working until that work authorization is approved. And your children shouldn't go to school until your green card application is filed. So those are the two common issues that we see for B1, B2, besides not having the intent upon entry into the US and then waiting 90 days after filing, similar to an F1 or an E2, and then finally similar travel restrictions to an F1 or an E2. And the bigger restrictions for the B1, B2 applicants is that they can't work until the work authorization is approved, and children shouldn't go to school until the green card application is filed. Now, this probably seems like a lot of information to give to you in a short period of time, and absolutely true. But this is why it's going to be important to speak to an attorney as soon as you decide what application, if you want to proceed with, and then they'll be able to assist you based on what status you're in, and then just hyper focus and give you a lot of information on that.
Exactly. I can't stress that point Anu just brought up enough. This is a complicated process. There's a lot of moving parts. And unfortunately, what you don't know is going to be a problem. So it's really important to work with an experienced attorney who's seen hundreds of cases, and we'll be able to quickly draw on that experience and tell you, what's going to be the path of least resistance. And also along that same line, let's talk about some USCIS mistakes. And this is another reason why it's so critical to work with an experienced attorney, because even if your attorney does everything perfectly, the government could still make mistakes. And when that happens, if your attorney hasn't seen those mistakes happen in the past, they may create a problem, which could be
exactly
an issue that'll result in a long delay or your application being denied, right? So I'll let Anu jump in, and she's seen hundreds of mistakes be made, and he knows how to address them and what can go wrong and how to fix it.
Right. So the first thing is that the government is constantly trying to update their systems, and it feels like they try to update their system without much vetting from their side. And so they release it to the public without really fine-tuning. And what I'm talking about is last year, the government started saying, we want to do everything in a myuscis.gov system, which means that when you file a 526 petition, the government will give you links and the attorney links to create an online account that you can use to track the system. And then they started issuing receipt notices that were different than what EB-5 was used to seeing before, and now they're being issued with a receipt number starting with IOE. And for the longest time, the government couldn't get that IOE receipt number to show up on the case tracking system. And of course, people started getting really nervous. Why can't I see my petition being updated? And that's because of the way that the government updated their system. It wasn't allowing for the tracking of certain applications, and you'd have to contact USCIS directly. Now that is slowly being resolved, and we're starting to see that being resolved, but that was one of the bigger issues, that it wasn't available on the website, so we had to make sure to monitor your case in other ways. Then we were seeing issues with USCIS saying that cases were not being delivered, whether or not that's EB-5 petitions, green card applications, RFEs. So it's really important to make sure that you had a full copy of your petition so that if the government came back and said, hey, these petitions were not delivered, you have a FedEx confirmation receipt that it was delivered and a copy of the filing, and you can reach out to the lockbox to say, here's proof that we filed it timely. We want you to honor the original filing date. And then there can be erroneous rejections where the government comes back and says, hey, the filing fee was wrong, or the addition date for the forms were incorrect, but you sent out the right one, and it's contacting lockbox and getting that resolved. So there's a lot of these USCIS mistakes that can seem really daunting if you're not consistently working with them and seeing sort of a pattern emerging and then quickly figuring out how to resolve those issues. So yes, you can absolutely do everything right and still have a USCIS error, but it's important then that your attorney knows that this error is now becoming common and then knows very quickly how to resolve those situations.
Okay, perfect. All right, let's spend a few minutes talking about EB-5 visa demand trends. So over the last 10 years, we've seen kind of ebbs and flows in terms of interest in the EB-5 program. Back in 2014, 15, 16, applications really spiked, and then during COVID and the lapse of the program, we see applications really dropped. But then over the last 2 years, we've seen a resurgence in applications with the RIA coming in place in 2022. And so you can see there on the right-hand side, demand has really increased over the last 2 years, and we expect that to continue. And part of what's driven that increase in demand is more confidence in applications getting approved faster. Since the RIA, there's been a new category created for rural set-asides. And in rural set-asides, there's priority processing. And so over the last 2 years, we've seen almost 200 5-60 approvals in our rural TEA projects. And what's interesting here is you can see that as time has gone on and USCIS has kind of figured out how to staff up and adjudicate these applications more consistently, we can see here that the more recently filed applications that have been approved, at the early part of 2024, we can see them, really mostly below 10 months in terms of approval timeline, which is a significant improvement over what the processing times were previously. And I know, Anu, a lot of your clients, prefer rural projects for exactly this reason. And could you share a little bit kind of about, why that's important for some clients and what you've been seeing in terms of time for rural project approvals for your own clients?
Sure. For rural projects, they have something called priority processing under the RIA passed in 2022, which meant that the government was supposed to prioritize adjudicating those types of petitions. And I will say the fastest I've seen for a rural project is about a month and a half, 2 months from filing to get a 526 petition approved. And then pretty much within 8 to 10 months from filing, we tend to see rural projects being adjudicated, which means that then the applicants are able to either file their green card application, or if they already have their green card application pending, the government can turn to adjudicating those. And as we get closer to a situation with a potential backlog, clients are trying to avoid that backlog. And you can avoid that backlog by having your green card application approved before the backlog hits. So even though we can't say for certain when the backlog will hit, clients are trying to hedge their bets and get their green cards approved as quickly as possible. And part of that is getting their 526 approved as quickly as possible, which is why we see more and more people interested in the rural projects, because those do consistently tend to see adjudications in under the 10-month mark.
Got it. Okay, that's really helpful. Let's talk a little bit about just big picture what the EB-5 market looks like today. And this is showing data through July 31, 2024. And we can see here that at that point, a little more than half of investors preferred urban projects, and about 40% were rural. But the trend is definitely toward more rural filings. This data is about 6-7 months old at this point. And then on the right side, we can see Chinese investors are about half of the applicants, a little more than half, and then India, and then the rest of the world makes up the rest. And so the main kind of overall point here is just there's more demand for rural projects. That's definitely what's trending now. And again, the reason for that is that now that time has elapsed and we can really see how many non-rural applications have been approved versus how many rural applications, there really is a difference with the priority processing, and that's really clear. And when we look at kind of the potential future of there being a backlog, it's important to look at the number of applications, but also the number of human beings attached to each application. The government allocates visas based on individuals. And so $1,800,000 investment might represent a husband, a wife, and 3 kids, which would require 5 visas, whereas another one could just be a single man without any children or a spouse, and that would only require 1 visa. So some of these estimates for the number of visas required, require estimates for the number of visas tied to each 800,000. And so when we look at the number of applications that have gone in to date for rural and urban, there's been more urban applications, and there's also fewer visas available for urban projects, a 10% set aside versus 20% for rural. So that effect of more applications and fewer visas results in a larger, potential shortage of visas, or said differently, a longer backlog in the urban category versus rural. There are many factors that will impact exactly what happens here. One of them being just how quickly applications get adjudicated, and thus how quickly visas are actually used up in both categories. But when we look at the total math, it's pretty clear that there's just a lot more people in line waiting for urban visas than rural. And so that's why, we're continuing to see in our applicants, in our projects and investor preferences, just a much greater preference for rural. Anu, what are your thoughts on this situation, and how do you kind of advise and give clients the information that is available while, still, telling them that, we're still not sure exactly what might happen, but here's what we do know today.
I love your PowerPoint on this, because this is exactly what I tell clients, that there are so many different factors that are going to impact the actual waiting time that I cannot guarantee or give you an exact timeline of how long the backlog will be. I go through what the industry is saying, what the possible sort of options are, and whether or not that can be increased or decreased, or why. People can decide that they don't want to do EB-5 anymore. I also manage our firm's EB-1 extraordinary ability practice, and I have applicants who do both EB-5 and EB-1. And if they get their EB-1, they drop out of the EB-5. And so you have people who naturally drop out of the process, or their children become 21, And I've had some investors who have gotten the green card lottery who drop out of the process. So there's multiple factors involved on why there can't be an exact prediction. But yes, the estimate right now that the industry is giving is about 5 years, and that can be plus or minus depending on what happens. What I tell clients generally is if you're interested in EB-5, the best time to file is going to be soon, because I'm not sure how long the backlog is going to be. And the most important part for a lot of my clients in the US is that ability to file for a green card concurrently with their EB-5 petition. And if there's no backlog, then they can do that, and they really don't feel too much impact of the backlog because they have a lot of what they want, which is ability to live in the US, work, and travel. So that kind of insulates them from a lot of the issues in the backlog if they're able to concurrently file that green card application before that backlog hits. So those are the points that I usually want to make sure that clients understand when they're looking at this potential for a backlog.
And speaking of backlogs, let's spend a minute and just talk about this recent visa bulletin warning and what that means for clients and what we've seen historically with respect to similar visa bulletin warnings.
Sure. So in the December notice for the January 2025 visa bulletin, the government came out and said, hey, based on the data that we're seeing right now, it may be possible that they'll need to establish cutoff dates for EB-5 category for rural and high unemployment in this fiscal year of 2025. And generally, the government has given us warnings like this 2 or 3 times, 3 times previously. The first time, as I mentioned earlier, was in 2015, where they gave us the warning in January for the February visa bulletin, and then they ended up establishing that cutoff by about May of 2015. Similarly, they gave us a warning in 2018, January for the February visa bulletin. They ended up establishing the cutoff in May of 2018. The shortest time, that was for Vietnam in 2018. The shortest time frame that we received was for India in 2019, where they told us of a possibility of a cutoff in May 2019 for the June 2019 visa bulletin, and then the cutoff date was established pretty soon after in July of 2019. So it was a little over a month notice that everyone received for that cutoff. So historically, the Department of State is pretty good about predicting these visa numbers. So when they say that there's a possibility for a potential backlog, I think it should be something that people take seriously, especially those who have potential aging out children, to consider filing sooner than later, because they've historically been pretty accurate with their assessment.
Yep, and let's just spend a minute and just talk about what we've seen happen historically with this type of.
Oh, for the visa bulletin. So the important part for a visa bulletin is that it comes out generally the 15th of the month prior. So for example, the January 2025 visa bulletin came out in mid-December, and then it will tell you what the visa cutoff dates will look like. So the reason why that's important and beneficial for a lot of applicants is that if they know there's going to be a cutoff established the next month, they can still have some time to go ahead and file for the green card application during that month. So let me give an example. Let's say on February 15th, 2025, the government puts out a visa bulletin and says, hey, in March 1st, a cutoff is going to be established. Everyone would want to file their application, their EB-5 and their green card application, before February 28th and for receipt by the government, so that they're not, they're not subject to that backlog as soon as it hits, and they already have their green card application pending. So in the example that is listed on the PowerPoint, we've put off, let's say that in February 2025, the government puts out a cutoff date that's going to start March 2025 for EB-5 high unemployment Indian investors. All investors that fall within that category would want to make sure that their application is received by the government by February 28th before that visa bulletin goes into effect. So that timeline is going to be really helpful to keep an eye out on. Every time I do a consult and the clients aren't ready, or the prospective clients aren't ready to immediately file, I send them a link to the visa bulletin and say, hey, keep an eye out on this. You want to make sure that you are keeping an eye out on this so you can file your concurrent green card application. Otherwise, if you miss that window of opportunity, you don't get that benefit of the work authorization and travel permit while you're waiting for your priority date to become current. The other risk, of course, is going to be that there's a small possibility that the government publishes the visa bulletin late, so you get a truncated period of time in order to quickly file something. So you don't want to do this process rushed if you can help it. So my recommendation always is to start the process a little bit earlier, so you have a little bit of breathing room and you can make, the best decisions and choices in this EB-5 process.
Exactly. Yep. This takes time. This isn't something that you can just hire on new and then 2 days later the application is going to be done. There's exactly. a lot of back and forth that's required, and in a few minutes, Anu will share some details about kind of what that process looks like, timing, and some of the materials. But before we get to that, we'll spend just a quick minute chatting about some of the different projects that are currently available. So on the rural side, again, these are the ones with priority processing and the faster approvals, which are at the moment certainly the more preferred options for most investors. Our Rocky River loan project, which is 956F approved, along with all of these other projects, which means the government's pre-approved the project for both immigration and at-risk requirements. This is a loan to a large developer, the Coulter Group, that's done more than 25 EB-5 projects and is an ongoing development, building and selling single-family homes to 55 and up active adult retirees. Second is our Tamarack Resort. This is a large ski golf lake resort in Idaho, where the developer's already sold over $100 million in real estate. All jobs already created, and construction is ongoing. And then on the urban side, we have two different options. Our Boynton Beach multifamily equity project. What's unique about this project is it has a 5% annual preferred return for investors and a short 3.75 loan term, or excuse me, investment term. And then our One Tampa loan project, which is a parent company guaranteed loan, also with the Coulter Group, who's developing Rocky River and Boynton Beach. And this project has substantial condominium sales already and follows 5 other successful condominium EB-5 project loans that we've done previously with Coulter. All right, so before we wrap up, Anu, could you spend 2 or 3 minutes and just kind of discuss what that source of funds process looks like in general, and how you and your team, work with clients to get through that process as efficiently as possible and submit an application, that has a very high likelihood of getting approved.
Sure.
Back and forth.
Yeah, one of the things that we do is once we are retained, we get on a long call with you to really go through what your different sources of funds are going to be. Once that's done, we'll send you a checklist of all of the documents to collect. And once that's collected, we review and see if there's any gaps in documentation or gaps in logic that we want to help fill in. Every step of the process will identify a few things. Is there going to be a request for evidence risk, and what we think the chances of a request for evidence is going to be, and whether or not we want to affirmatively provide documentation to prevent a request for evidence, or take the chance that there's a small risk for request for evidence. And this really depends on each client's appetite for risk. Some clients will say, I don't want there to be any chance, so I want to provide all documents up front. Some clients will say, look, I don't want the government to have all of my documentation. Can you let me know which ones you think are critical? And then if there's a request for evidence, we'll address that at that point. And so we really take the client's risk appetite into consideration when we decide how we're going to be presenting a case. But at the end of the day, we're of course going to try to minimize the risk for evidence regardless. And part of the way we're able to minimize the risk is that we are a team of attorneys who work directly with you. Our paralegal team will help in completing the forms, but we are the ones that are speaking with the clients directly, and we're the ones that are drafting everything. And we tend to be a little bit controlling. So during every consult, during every call, I tell clients, do not transfer money, do not consolidate money until I give you the okay in writing to do so. And that allows us to make sure that, clients haven't accidentally used a different bank account or money coming from a different place. And so we're pretty controlling of every step of the process. That allows us to really monitor and make sure that the client's case is going to proceed smoothly with USCIS. And I'm a big fan of charts. I think just having a wall of text is really daunting for USCIS officers. And my goal is to make a USCIS officer look at a case and go, well, obviously this should be approved. So adding charts, adding tables, not only visually breaks apart the data, but think of the PowerPoint that you saw here and Sam presenting data in multiple different ways. And some is just visually more appealing and makes it easier to understand a wall of text that you just previously read. So all of those little things were really going to be helpful in mitigating chances for a request for evidence. Now, Sam previously mentioned that, hey, this is not a short process. You want to make sure that you are taking your time to do things correctly the first time around. If you have a really simple case, absolutely things can be turned around quickly. A lot of my doctors don't move money around. They get money into one account, all of the money stays in that account, and they don't touch it. No other money is coming in. Super simple case. We filed cases in 2 to 3 days because of how simple they were. And then I recently had a client who had 40 properties that they were either selling or putting up as collateral for a loan. And then I had another client who had 10 friends and family who were gifting them funds, and each of them had different sources of funds. So whenever you have that complexity, that layered source of funds, it is going to take a little bit longer. And especially if your funds are coming from overseas and need to be translated, all of those are going to impact the timeline. So it's important to be realistic on how quickly your case can be filed, and that really goes hand in hand with how complicated and multi-layered your source of funds is going to be, and making sure that you're spending a little bit more time up front to try to prevent a request for evidence.
Got it. All right, that's super, super helpful, Anu. I think that pretty much covers what we wanted to get through on today's webinar. I know there's many other nuanced questions and things, and so for any follow-up questions related to an investor being potentially qualified to do EB-5 or eligible, sources of funds could work, please reach out to Anu. Her contact details are listed here on the screen. She'll be the one to help guide you through that process and answer questions. And anything related to any one of the projects that we talked about today or any other projects on our website, please feel free to use that QR code there or reach out to us, and we're happy to chat. But again, once you decide to do EB-5, the first step is really to select an experienced EB-5 immigration attorney, and Anu has our strongest possible recommendation. And then once that process is underway and complete, and Anu tells you, okay, your documents are ready, this is going to be approvable, we've looked through everything, then that's the point where you really finalize which project you want to join, and then you commit and make an investment, and then on you file your application. That's really cool. All right, perfect. Thank you again, Anu, for taking the time. We really appreciate it.
Perfect. Thank you, everyone. Thank you, Sam.
Okay, excellent.
Bye.
Bye. Thank you.